He was told, you can watch the video of the jury room to ensure what happened. And he said, no thanks, we're cool. Today we are going to go somewhere we rarely go. We don't do this a lot. We're going to appellate court. Charlie Adelson wants a new trial. Charlie Adelson was convicted of the same thing Donna Adelson was. I know a lot of you watched the trial. We did not watch the trial together. But God, we heard enough from Charlie Adelson and all of those freaking calls. So now that we are getting to the appellate court, we are seeing just the lawyers arguing about the motion for change of venue. Remember that appellate court works a little differently than what you see in your state level trial courts. They only review the record. They're not going to go watch it back on YouTube. They read the record. The thing I appreciate about the appellate court is that they really do just pepper the lawyers with questions. The appellate court is just like, what about this? And what about that? And what about this? And what about that? And they jump in and ask pointed questions of both sides. So for those of you who haven't watched appellate proceedings, you will notice that they are more formal and that they do interrupt the lawyers. I love that. I love seeing what the judge's questions are. We did not read the motions. We did not read the filing papers. A good attorney will be able to bring us up to speed on what their argument is very quickly. So I'm optimistic that that will happen here. Fingers crossed.
So let me begin with the jury selection claims. Claim 1 concerns the trial court's failure to grant the motion for a change of venue. Claim 2 concerns the trial court's failure to strike the panel, and then specifically, as that issue evolved, to strike the middle group of jurors, jurors 51 through 102.
When he says strike the panel, he means he wanted the court to yeet all the jurors on that panel. Yeet. All of them.
For reasons that I'll get into in a second.
I'm curious what those
Let me begin with the
reasons
change
are.
of venue argument. The numbers in this case are pretty striking. We know that of the 130 jurors who were...
Excuse me, Corey, you've got like 1,500. They had 130. They had 130 and they found a jury.
Questioned individually, and that's the way this process went. The judge began jury selection by individually questioning jurors in groups of 50. There were 3 total groups that were ultimately questioned to determine whether or not they've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were
out of 130, 53 jurors said, yeah, I heard about the case. Your dude did it. That still leaves a substantial amount of jurors that hadn't.
Questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require before...
Oh boy, counsel.
Those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know, and my response to that...
Isn't that the problem? It requires an affidavit. What would have been in the affidavit? Well, I don't know, because we didn't do one. Counsel, if there are 3 things that are needed, you didn't do them, it's going to be a problem. It's going to be a big problem.
We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection.
Yes.
That a judge is not going to grant a change of venue claim pre-trial.
Yes.
Sure, but one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that what types of media that the citizens of Tallahassee and this community were consuming. And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw. And I think that's right. But wouldn't the affidavits also have shown that maybe consumers curate their media differently?
Yes.
We saw in this transcript there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read
Oh, those jury affidavits must have been feisty. Because yes, the appellate court has the entire record, and the appellate court would be looking at all of the jury affidavits. And the appellate court is like, yeah, well, your jurors aren't watching TV.
All right, so specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief.
Oh, boy.
The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived.
Oh, boy. Remember when we talk about use it or lose it? This is how that plays out down the road. You have to preserve the issue.
In your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, three actually. Just quickly regarding my client accepting it. I don't know that my client accepting it matters much. I think the concern is did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was there an objection?
There needs to be an objection.
I understand. But again, so that I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it. But my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection.
Did it happen? You've said a lot of words. You've said a lot of words, but you know what you haven't said? If the objection was renewed.
In Patton, the U.S. Supreme Court said exactly this. Adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying that.
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse. Again, we can't presume that,
let me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said that's what we have here, you would say, Mr. Rufferman, you're speculating. We have two instances where jurors lied directly to the trial court.
What?
Are we supposed to just...
Who would lie to that judge? Can you imagine the fucking audacity?
Assess the credibility of these jurors? Is that what an appellate court is to do under this?
No, that's not what an appellate court is to do. That's not the role of the appellate court at all.
Lied directly to the trial court. Ask
So
point
are we
blank.
supposed to just
assess
the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record is two instances where jurors were specifically asked, have you formed an opinion about guilt in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had said that the parents of Professor Markell should assist in killing Mr. Garcia.
Oh, shit.
And then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I refer to him as.
Oh, shit.
The first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court no. Lo and behold, two jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
What?
And both of those jurors were.
That's so dramatic. What? So Juror T, have you expressed any opinion on this case? No. And is going around the jury room being like, this motherfucker is guilty. Oh, shit.
Both of those jurors were excused for cause, were they not?
Yes, but statistically, if those two, it's very
yeeted.
hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions.
I've never seen that happen in a trial. Defense counsel was given the opportunity to watch the recordings of the jurors talking in the jury room?
Of the other jury members, and defense counsel said, no, I don't want to see
it.
But here's the problem with that.
You're telling me that Adelson's defense attorney, after Juror T was walking around telling other jurors, this motherfucker guilty, he was told, you can watch the video of the jury room to ensure what happened. And he said, no thanks, we're cool? I've never even heard of that. This is the jury assembly room. This is not where they're deliberating. This is the jury assembly room before the jurors get picked. There is not recording in the jury room where they deliberate. Jury assembly room is different.
We know about halfway through jury selection, it's reported, number one, that jurors have not followed the judge's direction, so much so that the judge, when he heard about this after two of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors.
Can you imagine Judge Everett coming out and yelling at a 50-person panel of jurors and being like, I told you all not to talk about the case?
Pretty sternly, do not talk about this case. But we also know...
But the problem is the content of those communications. And they were like this, high-profile case. It's the Charlie Adelson case. It's the Dan Markell case. Which of the... And that he's guilty. But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have four statements, right? So we have one where a juror said, we've been talking about it all day, is literally the quote.
He's arguing that that whole group of 50 that was like chitty chatting should have been yeeted. And it seems that Judge Everett said, go watch what they're saying in the jury room then and come back and tell me if this group of 50 is tainted. And the defense attorney was like, nah. 8
of the jurors that sat on the jury came from this middle group, 51 to 102.
8 of the jurors that were seated came from the group that was, he says, chatting in the jury room.
I mean, he was mad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of the speculation if the tape
of the
jury assembly room had been reviewed and then some content specifics argued?
I think it's clear that this 50 was tainted. And if you go back to the Manning...
The appellate court coming in with the practical. Hey, wouldn't we just know if counsel would have just, I don't know, watch the tape? A quick minute to thank today's sponsor, Lola Blankets, because not only are they my favorite blankets, but also it has been so easy having a cozy blanket that is also machine washable without getting all weird. And if you want to make sure everybody's cuddling up with you on the couch this Valentine's Day, you might need to gift yourself a Lola blanket. You might want to get a Lola blanket that matches your paw nerd. Or if you are thinking, who is the friend that just immediately buys everything for themselves and I can never pick a gift for them? Lola blankets are perfect because it is a slice of luxury that they might not have thought of for themselves. But once you gift it to them, you will also notice how much they start gifting Lola blankets. It's literally the softest blanket I've ever owned. I love that Lola blankets come in a wide variety of sizes, so you can pick what's right for you. So if you're looking for a way to send a hug this Valentine's Day, a Lola blanket is a perfect way to send that comfort to the loved ones in your life. And for a limited time, you get 40% off select Lola blanket products when you use code LAWNERD at checkout. Just head to lolablankets.com and use code LAWNERD. Also, let me know which blanket you pick. I love the green one. I think I need it for the chair behind me. Let me know. Do I need it? I think I do. After purchase, if they ask how you heard about them, let them know it was the Emily Show. Case briefs. Wrap yourself in luxury with your Lola blanket. Let's get back to today's show.
One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The three justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. He's entitled to an impartial jury. He's not entitled to an impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel that will say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case.
Shouldn't happen.
In
It
every
does
case
happen.
that's tried this week at the Leon County.
There are absolutely people that walk into the courtroom, look at the defendant, and are like, what'd you do?
Let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what the pretrial publicity is. This isn't like Shepard v. Maxwell. This isn't like Irvin v. Dodd, where
it's a deep law school cut right there.
You know, Mad Dog Irvin was in the press, as serial killer in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show that of the 54 prospective jurors who had a considerable amount of media exposure, that 53 of them found that Mr. Adelson was guilty and said that they couldn't be impartial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
We have to give jurors credit. Just because this young man said that Mr. Adelson was guilty and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted.
I mean, saying that the victim's parents should go kill someone is a pretty strong take. However, how long ago was it? Because this case did take almost 10 years to go to trial from the time the killing happened.
In this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire.
Barely used all 10 of their peremptories? Then they must not have been that mad.
Let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case, in modern cases often, fair trial, a different trial, a different result. Right. Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case
There's
here.
no way
There's been no
he's
demonstration
gonna
of that.
be able to show that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't.
The state's argument is like, Your Honor, obviously. No. Well, that's what he's arguing. Excuse me, Your Honor, but he's wrong. The third point of the appeal is that there was a error in not admitting all of the text messages that Charlie wanted to admit during trial.
He didn't separate those out and offer those to the court and say, these are the relevant text messages, and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice.
Oh boy. The court's like, and if we had admitted those text messages, then Adelson would be up here arguing that it was error to admit those messages because it made the jury dislike him more. It prejudiced the jury against him, and those shouldn't have been admitted because they were unduly prejudicial.
I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case. And in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him.
And now you've got the state saying it might have been IAC for the attorney to ask to admit those against his client. And the court was protecting against it.
Is it really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel's part?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis, if something's more prejudicial than probative. In this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party?
Yes,
now,
sir.
I'm not going to allow you. I think that would harm yourself if you admitted that, so I'm not going to allow that evidence in.
Stop hitting yourself as a valid argument, I guess.
I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that, and because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not allow that to happen or be forced to allow that to happen.
Yeah, you can't let a party invite a mistrial like that.
Here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. And the text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content.
The content of phone calls isn't going to be proven by the content of text messages. But the defense is arguing that the court erred in not admitting all these text messages, and the state attorney arguing the appeal is like, no. We will keep an eye on the Adelson appeals. Remember, the judges are reading the entire record of the appeal. Thousands of pages, sometimes tens of thousands of pages. Cases go to oral argument much more slowly, and the courts are reading the entire case, the briefing, the research, and they have research attorneys researching the law with them. These are slow, nuanced processes where the courts have time to consider what's happening. This is not an immediate appeal, and it takes quite a lot of time. And then the judges will do their research after oral arguments. Then they will come together as a panel and discuss the case. This is going to take a lot of time. And then we will see what their order is. So I will circle back when we have an order on this and maybe take a look at some of the briefing on it as well. Charlie Adelson is asking for a new trial. This is not going to be his only appeal, I'm sure. We are going to see this continue to go on. We need to circle back on the issue of conflict. Remember, Charlie Adelson was arguing that his lawyers for his trial had a fundamental conflict because it was Donna who was in contact with them first. I think it is a fairly interesting and strong argument. I imagine when appellate counsel started talking to Charlie Adelson, appellate counsel was like, what the fuck is this? Because I really suspect that Donna's preferred counsel might have had a conflict in their allegiance to Donna before they ever started representing Charlie. Because other lawyers might have argued Charlie wasn't doing this. It was his mom. She's the one that did it. He was just a pawn of his mother. Mom did it. But if your lawyer has a conflict to the person you can point the finger at, it's a problem. And the day that Donna was getting ready to go to trial, the court was just like, this is a huge issue. I'm very interested to see where it goes. We saw it derail Donna going to trial in wild fashion. So we'll see. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.